Hello everyone, welcome back to my channel. Today's topic is that Houston Maritime Attorney. So I'm going to discuss on Houston Maritime Attorney and the applicable law in this video. So stay with me. Thank you very much. So just like any other industry, seamen are at risk for suffering work-related injuries anytime they are on the clock. The courts recognize this and are continually working to protect injured seamen through general maritime law. Maritime law gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation for any other suffering of medical complications. The following acts are fundamental to maritime law: Jones Act, Death and the High Seas Act, Limitations of Liability Act. Okay. General maritime law is the basic for all injuries sustained by seamen. It's important to have comprehensive understanding of the general law before delving into the subsequent act. Okay. History of Admiralty and Maritime Law. Maritime law, also referred to as Admiralty law, is nearly as old as the shipping industry itself and governs most accidents that occur on navigable waters. The law's roots can be traced back to the unwritten customs of nautical behavior of the Egyptians and Greeks. However, the earliest formal codes were established around 900 BC on the Greek islands of Rhodes. The original maritime laws and codes stemmed from the ancient customs and rules of shipping. For example, the doctrine of general average, the concept that all sea cargo stakeholders, owners, shippers, etc., evenly share any damage or losses that may occur as a result of a voluntary sacrifice of a part of the vessel or cargo to have the whole, can be traced back to the early shipping customs of the Rhodians. The concept of separate legal authorities regulating maritime issues was brought to the west of Eleanor of Aquitaine, who learned of the concept when she accompanied her first husband, King Louis III of France, to the Mediterranean on the Second Crusade. The term Admiralty law came from the British Admiralty courts, who presided over maritime matters separately from England's common law courts. As the US judicial system is based on the British system, amended Admiralty laws were gradually incorporated into our legal system soon after the Constitution was ratified. Though still based on industry standards and customs, maritime law is largely found in the US constitutions, treaties, and international conventions. Federal status, the general maritime law, and other judicial discussions, administrative regulations, and customs. When does maritime law apply? Perhaps most obviously, maritime law applies to events that occur on high seas, in other words, accidents that happen beyond the territorial waters of any country. Furthermore, maritime law applies to the territorial area, which are waters within 12 miles of the shores. However, the law's applicability becomes less clear further inland. Early in the United States history, maritime law did not apply to incidents that occurred within the body of the country and therefore exclude incidents involving the Great Lakes and continental island waterways. However, throughout the 19th century, the exclusive roadway maritime law is now applicable to navigable waters. A waterway is deemed navigable it by itself or by uniting other waters. It can serve as continued highway over which commerce is maybe certain or other states of foreign countries. Consequently, if a body of water is completely landlocked within a single state, then it's not navigable for purposes of admiralty jurisdiction. However, a body of water does not need to flow between states to be deemed navigable. A body of water may be deemed navigable if it's a link in a chain of bodies of water that can be used to service interstate commerce. Ultimately, the test of the commerce of one state must be capable of being carried into another state of foreign country. Once this test has been passed, it's likely that maritime law will be applicable even if it's a recreational vessel. Incidents that require Texas maritime accident attorneys. Houston Maritime's injury attorneys exist to help injured seamen or workers get the compensation they need to recover from serious injuries and offer long-term medical costs that occurred offshore. That includes any accidental that occur on navigable waters and in harbors of docks. Our maritime lawyers have represented clients who were injured in jack-up accidents, rig accidents, deck accidents, falls overboard, dredge accidents, shipyard accidents, cruise ship accidents, oil platform accidents, etc. Notable aspect of maritime accidents is that they are often devastating. Offshore oil rig explosions cause significant damage. Vessels collisions are frequently catastrophic, and oil platforms can unfairly change the lives of workers. Maritime lawyers fight to help workers recover their compensation they deserve, whether they are suffering after a major explosion or have injuries caused by unsafe working conditions. Our maritime attorneys represented more crew members of the Deepwater Horizon and the EI Faro than any other law firm. We not only understand maritime law but the practices and culture maritime employees. Speak with us to discuss your case. The basic of maritime law. Maritime law is derived from other sources, federal statutes and general maritime law being two of the most prominent. These sources provided some of the maritime doctrines that are commonly used in cases involving vessels. Maritime law sits from many of the basic legal tenets associated with the sea and seamen, including seamen's right to maintenance and cure are benefits that are insured seamen's rent and mortgage, utilities, property tax, homeowners insurance, and food. Cure is similar to workers' compensation benefits for land-based employees. It covers costs related to medical treatment for the work-related injury. A seaman is someone who is a captain or crew member aboard to vessel in navigation. Also similar to workers' compensation, maintenance and cure does not require that the seaman prove any fault, injury, and employee is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen is a statutory right to sue the employee for personal injury damages. However, a seaman must spend at least 30% of their own time working on a vessel to quality for the Jones Act. Not only does the Jones Act provide the seaman a statutory right to sue their employee, it also is the burden of proof needed to prove the question and the act are not removal of the federal court. So I hope you guys understand my lecture and you can use my speech and lecture on the hostel maritime law in your studies for educational purposes. Thank you very much for listening.